So we're just gonna go through some of this trial audio. The trial was on February 7th of 2022. Strike that. The trial was on February 7th of 2023. And when we get to the testimony, and maybe this happens in all criminal courts in America, the witnesses, they had 3 witnesses, 2 victim/witnesses, and then 2 Tecumseh police officers, like I said, Sergeant Wright and Sergeant Walsh. Now, when the prosecutor, assistant prosecuting attorney Isaac Snead, asks his questions of the witnesses, never once do they say, "I don't recall," "I don't remember," "I can't answer that." And then for the same days that I ask my question, there's a lot of, "I don't recall," "I don't remember." You know, I mean, maybe that's just, is that court in America? I don't know. So let's just go through some of this. I don't know how long of a video this will be, but we'll see.
Judge, plug in.
Oh, I gotta bring myself back. This is just my iMovie from Mac that I used.
This is in the matters Stephen Croswick, file 220778 and file 220779. Today is the date and time set for a jury trial. Are all parties ready to proceed?
We are.
And we'll stop right there. The charges were originally brought, and it was in Judge Shadler's district court. And then, I mean, I was arrested in January and early February by the Tecumseh PD. And then the case was dismissed in April. And then they brought them back with new case numbers. And I think that was probably in May that they brought the charges back. And then we didn't have a trial till February of the following year, February of 2023. Just to put that in there.
Yes.
Very well. Is there any preliminary matters that need to be discussed before we proceed?
I don't believe so, Judge. I'm asking that the witnesses in this case be sequestered, not to hear other witness testimony.
How did I get moved over there? My bad.
During the trial.
Very well. We're first going to have the jury witness who the witnesses are, so if there's any bias that they may have. And then we will have the witnesses sequestered, which means after that portion, I'll ask you to go into the hallway, make yourself available, but do not talk about the case to anyone, right? Is there anything other preliminary issues?
No, thank you.
Very well.
And this judge was fairly new. He was elected in November of 2022. And this is February of 23. So a fairly new district court judge. Formerly, he was a defense attorney with the Lenawee Public Defender's Office. Todd M. Morgan.
Deputy Varga, can you please bring the witness or the jury in, sir? I'm going to ask that you sit on that side.
Are you talking to me? No, I'm sorry.
And just a lot of little things were happening. When I came in that morning, I had a bottle of water, unopened bottle of water, and I was not allowed to bring it in the courthouse. Let them know I'm representing myself, pro se. No water was provided in the courtroom until after lunch. When I went to lunch, like I said, the sheriff of Lenawee County coincidentally ate lunch at the McDonald's the same day I did for lunch. And then when I got back to the courthouse, we went to enter, and they wouldn't let me bring my bag with my files and laptop in, which I had in the morning. And I guess this was a directive from the court administrator, the district court administrator. What's her name? Heidi Cannon. And then that's when I asked, is there any way I could get some water during this trial? You know, I'm talking. And a female deputy did get me some water, a couple cups of water, which I appreciated, and I thanked her. I even told the sheriff, you know, that was nice of her. I think we're all just getting set up.
Please approach. Witnesses, I will listen. I need to know their names that I have. Witnesses.
It's odd that the court doesn't have the witness list prior to the hearing, because they were submitted.
Case LKCIC. So Susan Brooks, I've asked for the witness. So Mike.
And I already felt the retaliation by the local city government and the local PD in Tecumseh. I originally planned to have some witnesses, my therapist, my next door neighbor, as character witnesses, and I thought better of it. I don't know if they would have been reluctant witnesses or not, but I didn't want them to be retaliated against because they have to live in Tecumseh. I was moving, so, or at this time I had already moved away. Yeah, almost a year I'd been moved from Lenawee County. So I didn't ask. My next door neighbor did write me a letter. That was very nice. And my therapist wrote a letter. Both were denied to be submitted as evidence by Judge Morgan. He said it was hearsay. So, even though my therapist's letter was in his own words, her letter was in her own words, his letter was on his ProMedica behavioral health stationery, with all that. But Judge Morgan denied the jury hearing or the reading of those or seeing of those because he said it was hearsay.
If you sit in the back row right over here. Yes, sir. Gentlemen.
And these are audio transcripts that were provided by the court reporter, Joanne Spade. She used to work down in the district court. Now she's upstairs in Judge Anzalon's court.
Ladies and gentlemen, are you ready? Okay. Ladies and gentlemen, this is in the matter of Stephen Croswick, file 220778 and 220779. Ladies and gentlemen, I'm Judge Todd Morgan, and it is my pleasure and privilege to welcome you to the 2A District Court of Lenawee County. I know that jury duty may be a new experience for some of you. Jury duty is one of the most serious duties that members of a free society are asked to perform. Our system of self-government could not exist without it. The jury is an important part of this court. The right to a jury trial is an ancient tradition and part of our heritage. The law says that both the person who is accused of a crime and the prosecution have the right to a trial, not by one person, but by a jury of 6 impartial persons. Jurors must be as free as human.
And how many people have never been called for jury duty? I lived in Lenawee County for over 40 years. I was never called for jury duty. I'm not sure anybody in my family had ever been called for jury duty that I remember. Maybe that'll be a question at Christmas. How are jury pools done and who gets picked, how they get picked? Seemed pretty random, but I wasn't right on top of it. It had it looked like a bingo tumbler that pulled numbers out of it. But as we continue, there's some questionable jurors on my jury. A jury in a misdemeanor trial in Michigan, you only have 6 jurors, not the 12 that you get in circuit court. and at least 3, if not 4, of the jurors on my trial are questionable.
Humanly possible from bias, prejudice, or sympathy for either side. Each side in a trial is entitled to jurors who keep open minds until the time comes to decide the case. A trial begins with jury selection. The purpose of this process is to obtain information about you that will help us to choose a fair and impartial jury to hear this case. During jury selection, I will ask you questions. This is called the voir dire. The questions are meant to find out if you know anything about the case. Also, we need to find out if you have any opinions or personal experiences that might influence you.
And I believe I submitted 10 voir dire questions, and I'm not sure he asked any of mine. We'll see. Maybe 1 out of the 10 I submitted that he said it wasn't relevant. It wasn't.
For or against the prosecution, the defendant, or any witnesses. 1 or more of these things could cause you to be excused in this particular case, even though you may otherwise be qualified to be a juror. The questions may probe deeply into your attitudes, beliefs, and experiences. They are not meant to be an unreasonable prying into your private life. The law requires that we get this information so that an impartial jury can be chosen. If you do not hear or understand a question, you should say so. If you do not understand it, you should answer it truthfully and completely. And if you do understand it, answer it truthfully and completely. If you don't understand it, then you
I think
can
I
ask for
had
clarification.
my I love
Please
the
do not hesitate to
Constitution
speak freely about anything you believe we should know.
sticker that day.
During jury selection, you may be excused from serving on the jury in 1 of 2 ways. First, I may excuse you for cause. That is, I may decide that there is a valid reason why you cannot or should not serve in this case. Or a lawyer, or in this case, Mr. Koroswick, from one side or the other, may excuse you without giving any reason for doing so. This is called a preemptory challenge. The law gives each side the right to excuse a certain number of jurors in this way. If you are excused, you should not feel bad or take it personally. As I explained before, there simply may be something that causes you to be excused from this.
And we'll get to the preemptive challenge later, and the reason I didn't preemptively challenge any jurors.
This particular case.
Jurors, please rise.
I think that was Joanne Spade that told the jurors.
Thank you. Do you solemnly swear affirm that you will truthfully and completely answer all questions about your qualifications to serve as jurors in this case, so help you God?
And there might have been 20 people in there, I think, the pool or whatever they call it.
I'd like to introduce you to the members of my staff. The court officer is Deputy Jeffrey Varga. My court recorder is Joanne Spade, and I also have Katharina Flint, who may also join us. This is a criminal case involving the charge of stalking. There are 2 counts, or 2 different charges, which I'll explain more fully later.
Which the prosecutors filed a motion, a joiner motion, to join the 2 cases. They were totally separate. They claimed these people didn't know each other or anything like that, but they demanded that and I objected to that, but that was denied by, I think that was Judge Morgan that denied that.
This offense is alleged to have
Judge Shaler recused herself, said she didn't want any part of this.
occurred in file 220779 on or about January 5th, 2022, and in file 220778, January 4th, 2022, in the city of Tecumseh, County of Lenawee, State of Michigan. These charges have been made against the defendant, who is Stephen John Croswick. Would you please introduce yourself?
To you or the jury?
To the jury.
Good morning. I'm Stephen John Croswick. I'm self-represented, which means pro per. Good morning. Thank you for being my jury.
Thank you.
The lawyer for the state of Michigan is Assistant Prosecuting Attorney Isaac Snead. Sir?
Good morning. Isaac Snead. I'm appearing on behalf of the defendant.
And would you
Quite an actor. He reminds me of Jonah Hill.
introduce anyone
Always has an on-point necktie. I mean, his tie knot is exceptional.
at your table?
I also have Sergeant Walsh and Sergeant Wright from
Two lying cops. He didn't say that, but
Thank you.
Thank you.
The witnesses who may be called in this case are made. Sir, are you a juror or are you just coming to watch the proceedings?
I was scheduled for court this morning at 10. My name is Devin Riggs.
you were scheduled? Excuse me. And they do this a lot. Very common in courts. They stack a bunch of cases on top of each other. So you have to waste your time and show up like this gentleman did, just to find out. Sorry, we're not going to have your hearing today. Sorry to waste your time. A notice could have been sent out, or maybe a phone call or a text message. It is, but no. They have you come down, show up. Kind of an inconvenience. It doesn't inconvenience any of the people in the system because they're all getting paid. It don't matter to them.
The witnesses who may be called in this case are Maritza Martinez, Barry Purse, Sergeant Walsh of the Tecumseh Police Department, Dawn McKenzie, Sergeant Wright of the Tecumseh Police Department, Bernard
Lukasic.
and Susan Brooks.
Somebody getting a ladder out there. What's going on?
Juror number 17, William Holstein.
Oh, that was the tumbler that Joanne picked the jury from. Excuse me.
Juror number 15, Jennifer Harrison.
Oh, and I did request to audio and video record my trial. I submitted a request that was denied as well. I'm not NBC, Dateline NBC, or Law and Order TV, but I do have a very small media company, and I was looking to audio and video record the trial, and that was denied by Judge Morgan to do so. and it was submitted in plenty of time. Actually, it was submitted very early. So that was denied as well. So I had to pay the big money to get the audio transcripts.
Juror number 13, Troy Fields.
Who? Who was that?
Judgment plugin.
Oh, we went too far, guys.
Juror number 15, Jennifer Harrison.
Okay, that's the first one. Juror 15.
Juror number 13, Troy Fields.
Troy Fields. Or Fields.
Number 27, Michelle Perkins. Number 23, Christina Lucas. Juror number 3, Carletta Arnold.
Carletta Arnold.
Now, I am going to ask all the jurors that have been called to listen to the questions, because if anybody is excused, you may be called. Thank you. Do any of you know any of the people that have been introduced, either by social contact, business, anything at all?
The two of the witnesses, I'm a retired certified medical assistant, and I gave their kids care under that.
Anything about that relationship caused you to be unable to hear and decide this case fairly? Anything about that relationship might cause you to give any extra weight or any less weight to their testimony, their position in this case? You need to verbalize, because we're recording.
I'm so sorry, no.
Would you?
So you don't know who these people are the day of, but you find out afterwards who these people are and who they're associated with, how they know certain people. But obviously you don't know the jury before you go in, so you're just going by what they're being honest about.
Feel at all embarrassed to talk about this case with them if you were to decide against their position today? And do you think it would have any effect, one way or the other, on this case? Have any of you ever been a member of any law enforcement body or prosecutor staff, police or sheriff's department? Do any of you have any friends or relatives who are on or have served on any law enforcement body or prosecutor staff, police or sheriff's department?
I do.
Anything about that relationship that would cause you to give more or less weight to the testimony of a police officer versus anyone else?
No, the woman that was the that acknowledged that she was whatever CMA, certified medical assistant, is personal friends with District Court Judge Laura Shadler. Didn't disclose that.
Do you think you could be impartial?
Yes.
Would you feel embarrassed at all if you were to decide against law enforcement's position today? Would you feel more inclined to find the defendant guilty because of this relationship? On the other hand, would you have the tendency to find the defendant not guilty just to prove you were being fair or something like that? Do any of you know anything about this particular case or have any knowledge of it?
No.
Do any of you have any family or friends that are employed by the city of Tecumseh? Do any?
She's also personal friends. One of them was personal friends with that I saw on social media. Personal friends with Tecumseh Tecumseh Police Department desk clerk Monica Andrews. And they didn't disclose that.
Do you have any family or friends employed by the county of Lenawee?
Right there. She should have said, yes, I have a friend that's the chief district court judge. I do. She didn't disclose that.
Have you ever experienced a conflict with your neighbor?
6 people, ranging in the ages, probably, I'd say 30 to 60. Never have had a conflict with a neighbor. Never. What? Not even a small conflict. I'm not saying it has to be. But never had a conflict with a neighbor.
Do any of you have any prejudice against a person who has been charged with a stalking offense? Anything about the nature of the offense charged in this case cause you to be unable to hear and decide this case fairly?
I think people in general have somewhat of a prejudice for someone that stands up for themselves and represents themselves pro se. There's so many people that are conditioned and programmed to only think that a lawyer can do. Gotta be a lawyer. Go ask a lawyer. Get a lawyer. And are of that mind. There's so many people that are still under the notion that all police are good and honest and have integrity and honor their oath. There's still a lot of people in this country that feel that way. Watch a little YouTube. It used to be said there's a few bad apples. There's many bad apples.
Have any of you or family members or your close friends ever been a victim of any kind of stalking offense? Anything about that would cause you to not be able to hear this case fairly? You have to verbalize that.
Somebody was a victim
Do
of
you think you
stalking.
could be impartial? You do not believe you could be impartial and hear all the evidence?
Oh, yeah, that's fine.
Oh, I think that was Coletta Arnold.
And would
She
you
misunderstood that
be
question.
inclined to find the defendant guilty because of this experience? Or on the other hand, would you be more likely to find the defendant not guilty because
See, that's why I wanted to video record the proceedings so I knew exactly who was talking after the fact. But I believe that was Juror Coletta Arnold.
of his experience? Have any of you or your family members or close friends ever been charged with having committed such an offense or similar one? I need all of you to verbalize.
No.
Thank you. Have any of you ever been a complainant in a criminal case of this kind?
No.
Now, will each of you, if you are selected to sit on the jury, give the defendant in the case before this court the same fair trial you would want if you were in their position?
Yes.
Yeah.
Can you be fair and impartial in hearing and deciding this case?
Yes.
Can each of you do that?
Yes.
Do you all understand that under our system of justice, that this defendant stands before you as an innocent individual, and he remains such until the people prove that he's guilty beyond a reasonable
And I'm still innocent.
doubt?
Yes.
You all understand that?
Yes.
Do you agree with that?
Yes.
Do you all understand and agree with the principle that the defendant is not required to say anything? He's not required to prove anything. He's not required to testify. He's not required to prove his innocence. The burden of proof is solely on the prosecution. Do you all understand that?
The burden of proof is solely on the state, on the prosecutor, to, beyond a reasonable doubt, convict the defendant. So the burden is on the prosecutor beyond a reasonable doubt.
Now, if you are selected to sit as jurors, do you understand that you are to be judges of the facts alone and allow the court to instruct you as to what the law is in this particular case? You are the finders of fact, but you are to follow the rules of law the court gives to you. Do you all understand
The
that?
finders of fact.
Do you all agree with that? If you are selected to sit on the jury in this case, would any of you hesitate to bring in a verdict due to any fear of public comment or private criticism that you might receive later on? Would any of you fear
Here
that?
you go. Here's the public comment and criticism.
I don't know how long this case will take to try. It could be relatively brief. It could go well into the afternoon or even another day. You never can tell until the trial is well underway. Do any of you have any business commitments at home, personal medical issues, anything that's going to interfere with your ability to fully concentrate on this case? Do you understand that this case is extremely important to the defendant?
Yes.
And do you understand that it is equally important to the people?
Yes.
And it is not fair to either side if while they are presenting their case, you are looking at your watch and not really paying attention. Do you all understand and agree with that?
Yes.
Do you all understand that the first step of fundamental fairness in any trial is the willingness to listen to both sides completely?
Yes.
Do you all agree with the principle that all witnesses are to be judged by what they say and not who they are? Is there anyone here who would believe a police officer simply because the person is a police officer?
No.
Don't do that.
Or treat an officer's testimony differently, whether more or less than the testimony of any other witness who might take the stand? Have any of you ever received a ticket, speeding, running a red light, been arrested for anything all the way up to murder? The reason why I am asking this is this. Is there anything about your experience that caused you to be upset with the officer or law enforcement or the prosecutor that might cause you to think, this is my opportunity to get back at them? Any of you feel that way?
No.
On the other hand, do any of you feel because I had to pay my ticket, then so should this guy? Do you all understand that whatever happened in your own situation has nothing to do with this case?
Yes.
We are dealing with what happened on January 5th, 2022 in file 220779 and January 4th, 2022 in file 220778 in Lenawee County, and that is it. We are not talking about any other case Do you all agree with that concept?
Yes.
Please approach.
Yes.
Mr. President, I did receive your request for I didn't ask because I don't feel that the equipment in this case. Is there any other questions or voir dire questions either of you would like asked?
See that he just tells me that I didn't ask any of your voir dire questions. One was, do they understand the Constitution and the First Amendment to the Constitution? That was one of my questions. He wouldn't ask that.
In this case, it is the law as I get it from this case.
Okay.
Any other questions?
No, people are satisfied.
Are there any challenges for cause to the people?
No, thank you, Girl.
Challenges for cause, Mr. Crosby?
Challenging a juror? Is that what?
For cause. In other words, is there a reason why one of these jurors should be excused by the court's initiative?
I do have concerns of the juror that has a relationship with a witness's children or
Two of the
has
witnesses.
a relationship. There's a relationship there. So
And I do believe that juror number 27 has answered the questions, and I believe that based on her answers that she could be impartial and would be. So I'm not going to have any challenges for cause for her.
okay.
Any other challenges for cause?
No, sir.
So right there, I asked that she be removed. He denied that. She already stated that she I'm assuming it's the two female witnesses in the case or victims or whatever of the alleged stalking that she knows them personally. I mean, you get kind of personal with the nurse when you're taking your kids in. You get chatty. And then come to find out after, reviewing some social media posts and whatnot, she's personal friends with the chief district court judge in Lenawee County. And didn't disclose that. When the question was asked, do you have any friends or family that work for the county? I mean, I guess it's a state judge, but I think that would have been the right time to say, well, I am personal friends with the judge in the next courtroom, the chief district court judge, who recused herself on the case, and then is former city attorney for the city of Tecumseh back in the day, as far as I know.
Preemptory challenges for the people.
We have none. Thank you.
Very hard to probably get a fair trial in your local county when you're dealing with local government, local police. I'm going to say it's probably very hard to get a fair, unbiased, just verdict and trial with those circumstances.
Preemptory challenge.
And they know that. And then he's asking me about the preemptive challenges, and at that point I just said, no, let's just let it roll. Because I read up on this, and I wanted to see what all they were going to do, and they did all kinds of stuff.
Just Mr. Crosby.
No, sir.
and this is just a misdemeanor. I mean, low-level misdemeanor stalking, which the whole thing, the statute is, I'm sure it gets abused a lot, charging people with this because it's not aggravated stalking, no threats, no violence, no nothing like that. It's very minimal what they need to charge you and prosecute with stalking. It's ridiculous. It's a waste of taxpayers' money. It's a waste of resources. But the city of Tecumseh retaliated, and the county of Lenawee as well. In my opinion.
So are both parties satisfied with the jury?
Yes, Your Honor. Yes.
Yeah,
Very
let's
well.
go. Because I could already tell.
Please raise.
Things was going to be shady.
Do each of you solemnly swear or affirm that in this action now before the court, you will justly decide the questions submitted to you, that unless you are discharged by the court for further deliberation, you will render a verdict, and that you will render your verdict only on the evidence introduced and in accordance with the instructions of the court, so help you God. Thank you. Thank you.
Oh, they all swore in. I do.
Thank you, ladies and gentlemen. We
So
now
help
have
you
our
God.
jury. The rest of the jury pool. When do we need to check? You will need to check with the recording tonight after 5 o'clock. But your services at this point are completed for today. Please check with the recording after 5 o'clock today. You most certainly can stay if you wish, but you can also go about your day. Thank you so much.
I don't blame you guys. That I know.
Ladies and gentlemen of the jury, you have been chosen to decide a criminal charge made by the state of Michigan against one of your fellow citizens. As is our custom, I'm going to give you a set of opening instructions. The paper used to charge the defendant with a crime is called a complaint. The complaint in this case charges the defendant, Stephen John Croswick, with the crime of stalking in file 220779 and also with stalking in file 220778, and reads as follows. In 220779, that he did engage in a willful course of conduct involving repeated or continuing harassment of Dawn McKenzie, the conduct being such that would cause a reasonable person to feel harassed, and such conduct did cause Dawn McKenzie to feel harassed, contrary to Michigan Compound Law 750.411H, in file 220777.
And I brought this up before. Judge Morgan even left it off there, and I probably should have. I'm not a lawyer, and I'm not even sure a lawyer would have caught that. Do I have that over here, or did I put that away? Where are those warrants? The complaints, or whatever. So he didn't acknowledge that to the jury, but it was put on. Dude, are they in here? So much paperwork. But on the warrants, it had an additional statute that the alleged activity caused physical harm and or death. Judge Angelo's Zoom. I don't know where it is, but I brought it up before. Let me see. I don't have it right here. I must have filed it back in my files. But yeah, that the alleged conduct caused physical harm and or death punishable by a year in jail. That was on the complaints, on both of them. How about that?
It's alleged did engage in a willful course of conduct involving repeated or continuing harassment of Martinez, the conduct being such that would cause a reasonable person to feel frightened or intimidated or harassed, and such conduct did cause.
Keyword, reasonable person. A reasonable person. A reasonable person.
Maritza Martinez to feel frightened or intimidated or harassed, contrary to Michigan Code Law 750.411H. The defendant has pled not guilty to this charge. You should clearly understand that the complaint I just read is
and I'm still not guilty.
A complaint is read in every criminal trial so that the defendant and jury can hear the charges. You must not think it is evidence of his guilt or that he must be guilty because he has been charged. The defendant is charged in file 220779 with stalking to prove and regarding Don McKenzie, and file 220778 in stalking regarding Maritza Martinez. To prove these charges, the prosecutor must prove each of the following elements beyond a reasonable doubt. In file 220779, first, that the defendant committed two or more willful, separate, and non-continuous acts of unconsented contact.
Willful, meaning you meant to do whatever they're saying you did. Non-consensual. So keep those two things in mind. Willful and non-consensual.
With Don McKenzie. Second, that the contact would cause a reasonable individual to suffer emotional distress. Third, that the contact caused Don McKenzie to suffer emotional distress. Fourth, that the contact would cause a reasonable individual to feel terrorized, frightened, intimidated, threatened, harassed, or molested. Fifth, that the contact caused Don McKenzie to feel terrorized, frightened, intimidated, threatened,
terrorized, threatened, intimidated, harassed, molested.
The prosecution must first prove that the defendant committed two or more willful, separate, and non-continuous acts of unconsented contact with Maritza Martinez. Second, that the contact would cause a reasonable individual to suffer emotional distress. Third, that the contact caused Maritza Martinez to suffer emotional distress. Fourth, that the contact would cause a reasonable individual to feel terrorized, frightened, intimidated, threatened, harassed, or molested. Fifth, that the contact caused Maritza Martinez to feel terrorized, frightened, intimidated, threatened, harassed, or molested.
And if you've watched any of my other videos, you'll get to know. You see a lot more of Maritza than you do Don McKenzie. Hello? Do I have any free weights? No. Okay. Bye. Sorry about that. So let's just finish up with jury instructions.
Now I will explain some of the legal principles you will need to know and the procedure we will follow in this trial. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case.
And I submitted a lot of video. I don't know if it was 30 videos, and they denied my submission, said it would be overwhelming for the jury. It's just too much info. It's just too much to, I'll be making a mockery of the court by submitting my video. So basically, you know, suppressing my evidence. I was going to show that the victim almost hit me with her car on January 4th, 2022, which my video's up. That she definitely has a kind of well, not kind of, seems to have a personal relationship with the investigating officer, Sergeant Walsh, and they get pretty personal in the body cams multiple times. And was able to show in my videos that Sergeant Wright lied about my truck not being at my house on January 6th, 2022. I mean, all these elements, but like I said, the whole system is, it's a rigged system. It's a rigged system. So keep that in mind if you're ever confronted with any of this. And be careful what lawyers you trust. Do that.
The trial follows this.
Be careful anybody you trust.
First, the prosecutor makes an opening statement where he gives his theories about the case. The defendant does not have to make an opening statement, but he may make an opening statement after the prosecutor makes his, or he may wait until later. These statements are not evidence. They are only meant to help you understand how each side views the case. Next, the prosecutor presents his evidence. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects. The defendant's lawyer, the defendant, has the right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all his evidence, the defendant may also offer evidence, but does not have to.
No, that's not relevant. That's what I heard a lot. That's not relevant. Anything that was pertaining to the Purse Funeral Home, not relevant. Anything related to Brooks, Mr. Brooks, not relevant. Not relevant.
Not have to prove his innocence or produce any evidence. If the defense does call any witnesses, the prosecutor has the right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses.
Like I said, I only called one witness, and that was my roommate from up here, just as a character witness to describe who and how I am. The prosecutor, Snead, basically said, you know, well, his witness is how he is up there. That doesn't mean how he was down in Lenawee County. And I didn't have anybody local because I didn't want them to get retaliated against. So.
After all the evidence has been presented, the prosecutor and the defendants will make their closing arguments. Like the opening statements, these are not evidence. They are only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence. My responsibilities as the judge in this trial are to make sure that the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of the case. As jurors, you are the ones who will decide this case. Your responsibility as jurors is to decide what the facts of this case are. This is your job and no one else's. You must think about all the evidence and all the testimony and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact, in this case, is final. Part of your job is deciding what the facts of this case are, is to decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject anything a witness says. You are free to believe all, none, or part of any person's testimony. Deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you may have based on the witness's race, national origin, or ethnicity, gender, gender identity, or sexual orientation, or religion, age, or socioeconomic status. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth? Or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or any personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in this case? When it is time for you to decide the case, you are only allowed to consider the evidence that was admitted in this case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. The questions the lawyers and Mr. Croswick asked the witnesses are not evidence. Only the answers are evidence. You should not think that something is true just because it was asked by one of the lawyers or Mr. Croswick. I may ask some of the witnesses questions myself. These questions are not meant to reflect my opinion about the evidence. If I ask questions, my only reason would be to ask about things that may not have been fully explored. During the trial, you may think of an important question that would help you understand the facts in this case. You are allowed to ask questions. You should wait to ask questions until after a witness has finished testifying and both sides have finished their questioning. If you still have a question, an important question after this, do not ask it yourself. Raise your hand, write the question down, and pass it to the court staff who will give it to me. Do not show your question to other jurors. If your question is not asked, it is because...
Oh, let's stop. Just a minute. I want to see something. Where is that? I don't know. I don't know where that's at right now. I gotta get more organized.
Because I determine under the law that the question should not be asked. Do not speculate about why the question was not asked. In other words, you should draw no conclusions or inferences about the facts of the case, nor should you speculate about what the answer might have been. Also, in considering the evidence, you should not give greater weight to testimony merely because it was given in answer to questions submitted by members of the jury. If you cannot hear something that is said or presented, or if you cannot see a witness or evidence, please raise your hand immediately. During the trial, the lawyers may object to certain questions or statements made by the other lawyer or Mr. Crosby.
I don't think I objected to anything.
I will rule on these objections
Maybe I should have.
according to the law. My rulings for or against one side or the other are not meant to reflect my opinion about the facts of the
He
case.
objected a lot.
Sometimes the lawyers and I will have discussions out of your hearing. Also, while you are in the jury room, I may have to take care of other matters that have nothing to do with this case.
And I think, just my opinion, to promote transparency and accountability in our courts in the U.S., I think jury deliberations should be recorded. So if there's a questionable verdict that comes back, you should be able to understand what's going on back there. How it, how they come up with their... I think jury deliberation should be recorded.
Pay no attention to these interruptions. You must not discuss this case with anyone, including your family or friends. You must not even discuss it with the other jurors until the time comes for you to decide the case. When it is time for you to decide the case, I will send you to the jury room for that purpose. Then you should discuss the case amongst yourselves, but only in the jury room and only when all the jurors are there. You must not talk to the defendant, the lawyers, the witnesses, or anyone who may be connected to this case. This means that you may not speak to these individuals, even if it has nothing to do with this case.
One of the jurors on her way back from lunch spoke to me while I was in the hallway. Basically, it was, I guess, it was pretty, I don't know what, harmless. She was just asking, is the jury going back in yet? I said, I don't think I was supposed to talk to you, but yeah. But she looked at me and asked me in the hallway, is the jury back in there yet? I don't remember which lady that was, but that was after lunch.
You should be very cautious about speaking to people because you might inadvertently speak to someone connected.
And I did request the security cameras for the hallways in the courthouse, and that was denied through FOIA. Even though I was previously granted on a different date when I had a hearing, I was granted the hallway security footage. They denied it on the day of my trial because a lot of stuff was going on out in the hallway, especially at the end of the trial. It was funny.
Connected to this case. This restriction is necessary to avoid...
It was like a show for
of any improper conduct on any person's part. If anyone tries to discuss the case with you or in your presence, tell them to stop. Explain that you are a jury and you are not allowed to discuss the case. If they continue, leave. Report the incident to court staff as soon as you return to court. When the trial is over, these restrictions no longer apply. When the trial is over, you may, if you wish, discuss the case with anyone. The restrictions I am about to describe are meant to ensure that the parties get a fair trial. In our judicial system, it is crucial that jurors are not influenced by anything or anyone outside the courtroom. Under the law, the evidence you consider must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because information obtained outside the courtroom does not have these safeguards, it could give you incorrect or misleading information that might unfairly favor one side. These restrictions start now and continue until I discharge you from jury service.
And out of the 5 witnesses, including the 2 sergeants, 4 of them lied on the stand multiple times. Mr. Purse, I don't think he lied. We'll get to his testimony. I don't think Mr. Purse really lied on the stand. Maybe a little bit.
It is your duty as a juror to decide this case based solely on the evidence you see and hear in this courtroom.
His business partner sure did, though.
You must not consider information that comes from anywhere else. This means that until you deliver your verdict, you must not read, watch, listen to, or receive any information, including opinions or commentary about the case, whether in newspapers, on television, the radio, the internet, or on social media platforms.
I was exhausted by this
You also must
time.
not research any aspect of the case during the trial. This means research using a cell phone, computer, or other electronic device to search the internet, as well as research with traditional sources like dictionaries, reference materials, newspapers, or magazines. You must not investigate the case on your own or conduct any experiments concerning the case, including investigation or experiments using the internet, cellular phones, computers, or other electronic devices. You must not visit the scene of any event at issue in this trial. If it is necessary for you to view or visit the scene, court staff will take you there as a group under court supervision. You must not consider as evidence any personal knowledge you have of the scene. You must not share any information about the case by any means, including cellular phones or social media. This means that even if you are not discussing the case with someone else, you may not post any information about the case on social media websites or in any other manner.
Now, Tecumseh is a town of only 8,000 people. A lot of people know each other. Especially when you're dealing with two business owners, Mr. Purse of the Purse Martinez Purse and Son, J. Gilbert Purse Funeral Home in Tecumseh, and family law attorney Michael J. Brooks, who was also formerly the city of Tecumseh's attorney at one point in time. So a lot of people know. Now, did they know who I was? Probably not. Pretty quiet guy.
If you discover that a juror has
quiet, unpredictable, and dangerous, as Mr. Brooks would say.
Violated my instructions, report it to court staff. You may take notes during the trial if you wish, but of course you don't have to. If you do take notes, you should be careful that it does not distract you from paying attention to all the evidence. When you go to the jury room to decide your verdict, you may use your notes to help you remember what happened in the courtroom. If you take notes, do not let anyone except the other jurors see them during deliberations. Your notes will not be examined by anyone, and when your jury service concludes, your notes will be collected and destroyed. In this case, the defendant, Stephen John Croswick, is representing himself. This fact should not affect your decision in any way. The defendant has the right to represent himself.
And the reason I did that is my lawyer, at some point, I started to really question whose side he really was on. And if he really had my best interest, he told me multiple times, they don't like you. They don't. Like, I don't care. He's talking about the prosecutors and the PD and whatnot. Like, hey, really? Okay. It's not about liking me. Saying I'm sure they don't like me. I don't like them either. Not here to be anybody's friends. It's strictly business.
And he has chosen to exercise that right. Possible penalty should not influence your decision. If you find the defendant guilty, it is the duty of the judge to fix the penalty within the limits provided by law. I may give you more instructions during the trial. After all the evidence has been presented, you will hear the lawyer's closing arguments. Following the closing arguments, I will give you additional instructions about the rules of law that apply to this case. You should consider all of my instructions as a connected series, taken all together. They are the laws you must follow. After my final instructions, you'll go to the jury room to decide on your verdict. A verdict must be unanimous. That means that every juror must agree on it.
They should record deliberations.
Must reflect the individual decision of each juror. It is important for you to keep an open mind and not make a decision about anything in the case until you go to the jury room to decide the case. You must not let bias, prejudice, or public opinion influence your decision. Each of us may have biases or perceptions about other people based on stereotypes. We may be aware of some of our biases.
We're going to just go through and play the audio from the trial straight through with narration. And not one juror out of 6, all 6 were swayed beyond a reasonable doubt by the testimony, because there was no evidence presented by the prosecutor's office. No video, no emails, no phone calls, no text, none of that. I don't know.
We do not express them. We may not be fully aware of some of the other biases.
And an attorney, I don't know who this gentleman was, did come up and said, no matter, before they came back with the verdict, he's like, no matter what happens, you did a really good job for what. And I mean, I don't know if you can win in a county like Lenawee. This makes me, the way this little trial, this misdemeanor trial, this would make you question bigger trials, murder trials, where people get life in prison. The way these prosecutors and police officers lie.
Take the time you need to test what might be automatic or instinctive judgment and to reflect carefully about the evidence. I caution you again to avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors, who may have different backgrounds and perspectives from yours. Excuse me.
Bless you.
Mr. Snead, are you ready to proceed?
Yes, Your Honor, the people have moved to sequester witnesses.
Any witnesses to this case? And ordering that you be sequestered, which means I'll ask you to step out into the hall, not to discuss the case with anyone, and not be near the doors of the courtroom so that you can hear anything. Thank you. Are all the witnesses now sequestered?
I came back to get my coat.
Rakes. I think you're coming back in the afternoon.
All right. Are all witnesses now exited the courtroom?
Yeah, sure. The court would like to address Mr. Riggs. I think he was coming back in the afternoon, so.
And I did get, when I requested the transcripts from Lenawee, I don't know if they've updated this yet or not, but they're still putting them on CDs. I didn't have anything that played a CD. Everything's, digital flash drives or hard drive. I had to dig out an old laptop, and the software that they were used, I couldn't get it to cooperate with any of my Apple or Mac stuff, so it was all Windows based. So yeah, that took a little bit. Some of it I took to the local library in in Tecumseh to do some stuff with, because they still had some CD-ROM drives. But yeah.
Mr. Rakes? Yes. Please come forward.
Almost done here, and we'll and then continue with the testimony
Good morning. It's my understanding
in a different video.
failed to appear earlier, but a show cause was issued and not a bench warrant. I'm going to ask that you come back on Thursday, February 9th.
This is February 7th when he's there.
At 8:30 in the morning.
Okay, all right, thank you.
Great. Thank you, Mr. Snead.
May I proceed?
You may.
Thank you. Good morning again. Isaac Snead on behalf of the people.
Okay, so we'll stop right there and pick up in a different video. I don't want to make it too long. It's like 45 minutes. So you heard these jury instructions from the judge and how they're supposed to determine, you heard the jury selection. You heard my objection to one of the jurors after acknowledging that she was the CMA at Lenawee health specialist there in Tecumseh for many years. What else did you hear? You heard that my voyeur questions were not he didn't present any of them to the juror. One being, do you understand the First Amendment to the Constitution of the United States of America? What it says. The different elements. Freedom of religion. Freedom of speech. Freedom of the press. Freedom to redress your government without retaliation. And then freedom to peacefully protest. Do they know those? Probably not. Most police officers in this country don't know those. But we'll pick up with the rest of the trial. Stay tuned or whatever. Thank you. Whatever. Like, share, subscribe. I'm not really looking to get YouTube famous, but I think it's beneficial to get this information out, to share with the public. I've learned a lot from YouTube. Not claiming to be a know-it-all like Sergeant Walsh says. I admit when I'm wrong about things. I'm not a narcissist. We all make mistakes, and your ability to admit to them and whatnot is big. I don't know everything. I'm learning every day, always learning, never too old to learn. And I'm a free thinker. I'm not a follower. Don't be a follower. Be your own thinker. I don't like it, but be your own thinker. Be your own person. Stand up to the bullies. Peace out, y'all.